As the petitioner, Solicitor General Elizabeth Prelogar opened with the arguments for the United States.
Mr. Chief Justice, and may it please the court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria.
Let's start with two truths and a lie. The first truth is that this law does prohibit the use of certain treatments for minors for the purpose of changing their body to appear different than their sex. The second truth is that the law claims to overrule the decision of the minor, parents, and doctors. The lie is one we're going to see a lot in these arguments, the concept of birth sex. But more on that later.
Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational.
There are many laws that place the state's view of what is best for a child above the decisions of their parents and others. The state also regulates the use of drugs and treatments. Now, this can be a tricky situation, having the state overrule the decisions of a parent. If the state can remove a child from their parents for the child's safety, though, why not prevent treatments that both the state and much of society find harmful to the child? In other words, is it irrational to protect children from drugs and other procedures that have long-term negative consequences?
That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can.
Here's another lie, the idea of sex being assigned by someone. It's not like a baby is born and the doctor decides for themselves what sex to assign them. It's not like the doctor picks the baby up by the feet, goes into a drawer, and finds sex organs to stick onto him. They're not a Mr. Potato Head. A person's sex isn't even determined at birth, but at conception. When the sperm meets the egg, the sex is determined. It does not happen at birth, and it is not assigned.
If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care. But here, Tennessee made no attempt to tailor its law to its stated health concerns.
We will find that the plaintiffs and several of the justices will focus on sex, as if drugs cannot have drastically different effects when given to people of different sexes. It appears they believe there is no real difference between male and female. Again, more about that later.
Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB 1 can be reviewed under the correct standard. I welcome the court's questions.
Part of the petitioner's argument focuses on who specific drugs can be used on. This is a case of missing the forest for the trees, as we'll see later. Now, after giving her opening argument, General Prelogar answered questions from the justices, the first of which came from Justice Alito.
General, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition.
General Prelgar claims that there is overwhelming evidence that so-called gender-affirming treatment improves both the physical and psychological well-being of the patient. I say so-called gender-affirming care, since the care actually denies a person's gender in favor of their mental confusion. However, the Swedish National Board of Health and Welfare report that the risk of such care is likely to outweigh the benefits.
After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks.
A 1-2 punch from Justice Alito. First the Swedes and now the United Kingdom point out to the fact that the evidence that these treatments are beneficial are of questionable quality. I guess it's a question of who you should believe, an attorney or nation's Board of Health.
And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at.
Yes, there's a lot of debate about the effectiveness of these treatments, but let's not worry about all that. Could these treatments be medically necessary? Yes, and the law states it is not a violation of subsection A if a healthcare provider performs or offers to perform a medical procedure on or administers or offers to administer a medical procedure to a minor if the performance or administration of the medical procedure is to treat a minor's congenital defect, disease, or physical injury. Which brings up another question. Is a drug or surgical treatment medically necessary for a psychological condition? This is where Justice Sotomayor started asking questions.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide?
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
Do young people suffer from gender dysphoria? Yes. In fact, most of us suffer through puberty. Now, some adolescents even considered suicide. Again, the question remains, is the proper treatment for a mental disorder drugs and surgery? In response to one of the questions, General Prelgar pointed out that one of the states that restricted access to such treatments used a more targeted approach.
West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
West Virginia chose a different path. They require 2 doctors to diagnose the gender dysphoria and mental health screenings. That was how West Virginia's elected legislators decided to deal with the issue. But should Tennesseans be forced to follow the same path? There's still the question of the medical necessity of drug and surgical treatments for mental disorders. especially when those treatments lead to infertility.
I do want to acknowledge that there is evidence to suggest that gender-affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility, so I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity.
Are using puberty blockers simply pressing pause on a person's puberty? Well, if that were true, then why would these drugs be used to chemically castrate sex offenders? Now, from my research, puberty blockers are used in women to treat endometriosis, but only for 6 months. A second 6 months treatment can be used, but only when supplemented with the female hormones estrogen and progesterone. While puberty blockers may pause puberty, what happens when a person's body passes the age where puberty can happen? If their body hasn't developed the ability to be fertile, then they are by definition infertile.
With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks.
Since the purpose of these cross-sex hormones is to prevent the development of the very things that make us male or female, I find it difficult to see how they cannot adversely affect fertility. Is it a question of the people remaining fertile or being made fertile with the use of more hormones?